Well, hello everyone, and thank you so much for joining me on this live stream session. I'm Lior Samfiru. They call me the employment lawyer, and this is your live stream session on employment law where you get to ask me questions about your workplace rights, and I read them and I answer them. It's as simple as that. That's all you have to do is ask your question, type it in, hit enter, and I will read it and answer it. Of course, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find my firm across Ontario, BC, and Alberta. And that's what we do every day. And that's what I do on this live stream session. I solve workplace problems. I give you important information, knowledge. I tell you what your issue is, how to deal with it, what the law says, what your options are. This session is for your benefit, is to empower you and make you understand some of the laws that you have out there working for you. So many people don't actually understand that we have some fantastic employment laws across this country. They assume that there's nothing that they can do, that the law does not protect them. Well, I'm here to tell you that's wrong. Whether you lost your job, we have laws that make sure that that's done properly and that you're compensated properly. If your job has changed, your compensation, your hours of work, we have laws dealing with that. If you're put on a temporary layoff, we have laws dealing with that tell your employer, not so fast, can't do that. If you're being bullied, mistreated, discriminated against in the workplace, we have laws dealing with all those things. So on this session, if anything that you're concerned about has happened to you, why not just ask the question? Let me help you by giving you some information, by telling you what this all means. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and this is your live stream session. I can sit here and talk about employment law all day, but this works so much better if you give me your questions and give me that opportunity to help you and get your questions answered. I see some questions have started coming in. I'm going to answer them. Before I do, I want to give you some other contact information. If you want to connect with me and my team across the country, very, very easy to do. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. All the phone numbers you need are right there. The email address you need is right there. You can even fill out a form and we will call you. Very, very easy to connect and get some help, get us to roll up our sleeves and help you. But again, this is your live stream employment law session. You know, not too often do you get to speak with one of the top employment lawyers and ask your questions. There's no bad questions here, and get those questions answered. So take advantage. I'm here for you over the next 30 minutes. You have time now to think about your question and answer it and get it answered. Maybe you've always wondered about something. Maybe you're concerned that what your employer is doing is not legal, or maybe you're just curious. No problem. Ask the question. You'll get an answer from me. Again, I'm Lior Samfiru. Let's see. I think it's time to start answering some questions. Let's do that right now, okay? And in the meantime, as you're listening to me, ask yours. Our first question today, right out of the hop, it's from Warren. Warren says, my job expects me to arrive 15 minutes early unpaid, but I can only get there 10 minutes early due to transit. If I'm not at my post exactly on time, can they dock pay or discipline me? Do I have any rights here? You do. Your employer cannot expect you to be at work and required to be at work unless you're paid for it. There's no such thing as unpaid labor. Now, if you're on a salary, so you don't get paid by the hour, you just get a fixed amount of salary, then your employer can decide, well, your shift really starts this time, 15 minutes early, and you kind of have to be there. But if it's an hourly type of pay and you're starting to get paid, I don't know, at 10, but your employer says, no, you have to be here at 9:45, no exceptions. No, they can't do that. That's illegal. And not only can they not do that, if you don't do that, they are not allowed to punish you for it. That would be what we call a reprisal. You cannot be punished for refusing to be unpaid. There's no such thing as unpaid labor. It doesn't work. We don't have that in this country. So if your employer is going to do that, is going to require you to be at work but not pay you for your time, let me know. You can even file a complaint with the Ministry of Labor. Trust me, once they hear from me or from the Ministry of Labor on this issue, they'll back down completely. Okay, I've seen this issue come up very frequently. Keep in mind, though, this applies if you're an hourly employee. If you're a salaried employee, different, right? because you're not getting paid by the time, you're getting paid a fixed amount. So if you're an hourly employee, not legal, let me know if they won't back down. Let me know if you need my help. Yeah, very ridiculous for an employer to think we can have an employee do what we tell them, but we don't have to pay them. It's free. No, doesn't work that way, okay? Does not work that way. Completely illegal. So thank you for that question, Warren. Follow-up questions, you know what to do. Happy to connect with you right now or later. To connect with me later, off social media, off live stream, very easy to do, employmentlawyer.ca. Thank you for that question. Very great question. See how easy it is? If you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here with you answering questions live, just like I did now with Warren. You can ask your question. You have time, so please ask it. I want to be busy. I want to be hopping. By the end of the session, I almost want to be out of breath because I've been answering so many questions. So let's make sure that happens. All right, let's continue answering some questions. Our second question today, next question is from Manny. Manny says, I was terminated from my retail job after taking 2 approved sick days, despite having no prior warnings or performance issues. I had been employed for 18 months and believe I was in good standing. I'm wondering if this could be considered wrongful dismissal and if I might have grounds to negotiate a severance or settlement. So we have to start answering this question by defining, I should say, what is a wrongful dismissal. A wrongful dismissal really has nothing to do with the reason you're let go. A wrongful dismissal is a situation where you're let go without proper severance, okay? So in your situation, what you didn't tell me is, did you get severance, if any, and how much? Because the issue here is not that they let you go when you took approved sick days. They can do that as long as they pay proper severance. Now, I don't know how old you are and what kind of a job you were doing. I just know you were there for 18 months. But depending on your age and position, you could be owed anywhere from 2 to 6 months of severance. Months, not weeks, even though you only worked for 18 months. So the real question to me is, did they pay you proper severance? If they didn't pay you any severance, or they didn't pay you enough severance, yeah, you better believe that's a wrongful dismissal, and I can help you get that severance. If they paid you the right amount of severance, then it's not a wrongful dismissal. There's nothing that needs to be done here. But I would bet any money, Manny, that you're owed much more severance than what they gave you, if they gave you anything at all. So to connect with me, as I said before, so easy to do. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. See that address over there? And all the contact information you need is right there. So please take advantage of it. And I'll be happy to chat with you. Great question, Manny. Thank you for that. And I want to remind everyone out there that just because you didn't work for a long time, in Manny's case, 18 months, not a long time, it doesn't mean that you don't have substantial termination entitlements. You could be owed many months of severance, even though you only work for a short period of time. It doesn't matter who you are, how long you've worked. If you lost your job, call me always. You may be shocked by how much you're actually owed. All right, thank you for that question. Very good question. I'm Lior Samfiru, the employment lawyer. If you're just joining us, I see some questions more have come in. I want yours as well. I'm going to answer the questions that have come in right now. But in the meantime, please don't let this opportunity go by. Ask your question. Let me help you. Let's make sure that you get the answers that you deserve. All right, James. James has our next question. If I was hired for a 6-month contract and they let me go at 5 months, effective immediately. So here's how that works, James. If you're hired on a fixed term contract, okay, so in your case, 6 months, if your employer wants to let you go before the end of the contract, they can, but they have to pay you the balance of the contract. So in your case, if you're let go 5 months into a 6-month contract, means there's another month left on it, they would have to pay you for that extra month. Now, that could change depending on what the employment agreement actually says. I would want to see that. But that's the general rule. If you're let go before the end of a fixed term contract, you have to get paid the balance of the contract. I've had a situation recently where someone signed a 2-year contract and was let go about 3 months into that 2-year contract. Well, guess what? The company had to pay him for the balance of the 2 years, for another 21 months. So that's what happens with the fixed term contract. So they don't have to continue employing you, but they have to pay you. So James, the best advice I'm going to give you right now is reach out to me off air. Let me see that contract. Okay, let me see that 6-month contract. Once I've reviewed it, I'll be able to tell you exactly what you're owed. So James, to connect with me, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. All right. Let's see here. By the way, if you're just joining us, hey, I'm Lior Samfiru. You're listening to me right now. I'm the employment lawyer, and this is your live stream session on employment law. This is where you get all the answers you need about workplace rights, so take advantage of it. Excuse me. All right, let's continue answering some questions. I see Margaret has a bunch of submissions here. Let's see if I can get through them. Ideally, just so you know, if you're asking a question, you want to do it in a few lines so I can read it properly. If you're asking me a very long question, this may not be the best form. You can reach out to me directly at employmentlawyer.ca. But let me see what I can do here. Margaret says, I'm 62 and have worked with my current employer for over 4 years. They are closing the location and moving 100 kilometers away and have told me I have my job in the new location. No increase into my salary. I was given a letter to sign if I'm taking the job. If I choose not to accept a new location, how much severance would I be entitled to? As it will be difficult to find a new job. So here's how it works. So the question is not how far they moved, Margaret. The question is how much longer is it going to take you to get to the new location versus the older location? So, for example, they could have moved 100 kilometers, but that could end up being closer to you than the original location. So the real question is, did they move further to the extent that now it's going to be longer for you to get there, and how much longer? Generally speaking, if it's going to be an extra hour to get to work beyond what you used to do, then that's a constructive dismissal. That's not something that they can force you to accept. And if it's the extra hour and if you don't move, that's a termination of employment and you're owed severance. Now, I know you've been there for 4 years. I don't know and I believe you said you're 62. I don't know exactly the job that you're doing, but you'd be easily owed 6 months pay and potentially more than that. It could be as much as 10 months pay, depending on the job that you're doing. So the threshold here that I like to use is the hour. Did this move or will this move mean that you now have to drive an extra hour more than you used to? If the answer is yes, that's a constructive dismissal, meaning you're owed severance. The best advice, Margaret, I'm going to be able to give you right now is this. Don't do anything. Don't say yes or no until we've spoken properly, okay? I want to understand more about your situation. I want to understand more about any employment agreement that you may have signed 4 years ago when you started. That could potentially change the analysis. So that's the best advice. But overall, generally, it's that 1 hour threshold, not so much the kilometers that matters. Sometimes a company can move only 10 kilometers, but it could still take you that much longer to get there. So that's really what we're looking at. So Margaret, hopefully that helps. Any follow-up questions, ask them right now. But again, best advice is let's talk about this before you respond. Call me. Let's set up a time to speak. Again, you just said that it would be 3 hours to your travel time each day. So that is a constructive dismissal. But I'm still going to stand behind what I said. Before you respond to them, before you say yes or no or maybe, let's have a proper discussion. We're talking about your job. We want to do this correctly. We want to dot our I's and cross our T's. So reach out to me and let's connect. And you can do so, Margaret, through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that very much, Margaret. Very important question. I'm glad you asked that. People faced out those situations, and yours is a classic example of a constructive dismissal. So, Margaret, you know what to do, employmentlawyer.ca. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. This is your live stream session where I answer your questions, just like I've been doing. You still have time to ask yours. More questions have come in. I see them. Let's continue asking them. Or let's continue answering them. You continue asking them. I'll continue answering them. All right, our next question comes to us from YouTube from Harry. I'm on a medical leave and made it clear I intended to return. When I tried to initiate a gradual return, my employer suggested a demotion and a pay cut, then delayed things by requesting more medical info. due to health issues, I missed some emails. The last one warning of termination for job abandonment, which I only saw after the deadline. Could this be wrongful dismissal? Well, this is not something I can answer right now because I need a lot more information. I will need to see the emails. I will need to see what you gave them, how they responded. I need to know the time frames. Did you not get back to them for 2 days or for 3 months? So I would need to see all those things. Generally speaking, your employer has to accommodate whatever your doctor says your limitations are. So if your doctor says you need gradual return to work, they can't really question that. They can't say, well, we don't believe you. We want to speak to another doctor, or we need you to give us your entire medical file. They don't get to do that. They really need to do what the doctor says. So if they refuse to do that, that alone could be a constructive dismissal and potentially even a human rights complaint, regardless of what happened after. Okay? So that's where the devil's in the details. I would want to know, did you give them a doctor's note? What did the doctor's note say? How did they respond? What happened after? So the best thing I can tell you in this case, Harry, is let's connect off air. Let's have a proper conversation. There's obviously a lot at stake for you. I get it, which is why we want to do this right. You can reach me through employmentlawyer.ca. That address is on the screen right now, employmentlawyer.ca. And we can have that discussion and make sure that I provide you the help that you need. Okay? Thank you for that, Harry. Appreciate it. Look forward to connecting with you through employmentlawyer.ca. All right. More questions have come in. You guys are always fantastic. You're asking me questions. You're making it interesting. Thank you. And by the way, if you give me the opportunity to help you, we're also helping others who are watching who may have the exact same issue and the same questions. So do it for yourself, do it for them, and let's make sure you get all the information that you need. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Next question today, excuse me, comes from Katie. I was laid off after a medical leave. Is 3 weeks severance sufficient for 3 years of service? I agreed in email. Did I make a mistake? So no, 3 weeks is not even close to being sufficient. Again, I don't know the type of job that you were doing or your age, but you could easily be owed as much as 6 months of severance, not weeks, but months. So no, that's not even close. Now, obviously, I haven't seen the email. It's probably okay. We can probably get you out of that email, but of course, I want to see it. It's never, ever, ever a good idea to accept something without getting legal advice. Like I said, in your situation, the difference can be between 3 weeks and 6 months. That's a massive difference. That's obviously tens of thousands of dollars, right? So please don't ever accept things. But in your case, Katie, we can probably get you out of this. You need to connect with me immediately. Time is not your friend right now. Connect with me immediately through employmentlawyer.ca. Again, employmentlawyer.ca. And while we're at it, for Katie and for anyone else out there, if you want to know what is the proper severance amount, in Katie's case, she was offered 3 weeks. That's not even close. So what is the proper severance amount, and how do you find out yourself? You can do that in seconds. All you do is you go to pocketemploymentlawyer.ca. The address is right over here on the screen, pocketemploymentlawyer.ca, and you click on the severance calculator. That's all you have to do. You answer a few questions, and it's going to calculate and tell you, are you owed 10 months severance, 18 months, 24 months? It's going to calculate the right amount. It's completely free and anonymous. No names, no phone numbers, no email addresses. It's just there for your benefit. You can even contact me directly from that severance calculator if you want, and only if you want to. But again, check it out. You'll be shocked by how much you're owed. You may think, oh, I know. I get a week per year, or I get 2 weeks per year. Wrong, wrong, wrong. It's not that. It's much more. That's why we have the severance calculator. Again, pocketemploymentlawyer.ca is there for you. Check it out. Well over 2 million Canadians have used it already. Use it as well. Thank you for that, guys, and check it out. And you can connect with me right there. But right now, I am still live. Okay, and Katie says she's 38 and in a housekeeping role. Yeah, you're probably owed anywhere from 4 to 6 months of severance, Katie, 4 to 6 months. Now you know, now you want to connect with me. Again, employmentlawyer.ca. Guys, you still have time. If you ask your question right now, I guarantee you'll still get an answer from me on the session before we're done today, okay? So let's continue answering. I'll do that right now, but please, you have kind of your last chance to really formulate your question. So let's make sure you get it in there. Okay, Renee. Okay, Renee says, you have said it takes 3 or more fixed-term contracts to be considered an indefinite employee. What if there's only been 2, but have worked at the company for 15 years? Is that also indefinite? Yeah, it probably is. I would want to see the contracts, but no one's going to say that after 15 years you're on a fixed-term contract. So yeah, you're likely an indefinite employee, and that becomes relevant if the company wants to let you go. They may say, well, you're on a fixed-term contract now. The contract is ended. So we're letting you go, but we're not paying you any severance because the contract just ended. Well, if you're really an indefinite employee, then of course you're owed severance. They're allowed to let you go, but they have to pay you severance. And listen, for you after 15 years, that could be a year's pay. It could be even 18 months of pay that they would owe you, a substantial amount. Obviously, as I've said before, the devil's in the details. So I would want us to connect. I want to see the contracts. I want to understand exactly what you've been doing over the past 15 years, your job, etc. But definitely, if you are let go, man, oh man, you have to connect with me right away so that we can make sure that you're not being deprived of what your legal rights are. Okay, thank you for that. And you know how to reach me, employmentlawyer.ca. By the way, if you're joining us for the last few minutes here, thank you for coming. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin, LLP. There's some more questions here to answer. I want yours. You can still ask it. You can still get an answer. So don't wait. If you wait more, you're not going to get an answer today, and they'll be saying, well, I wish I would have asked Lior. Don't wish. Ask it. I promise you there's no such thing as a bad question. All right, let's see. Next question from Breeze. I resigned from my current role in Ontario and gave my 2 weeks notice. I was walked out the day I gave my notice, but not paid out for the duration of the 2 weeks notice period. My ex-employer sent a letter stating that my last day of employment is the day I gave my resignation letter and not the end of my 2 weeks notice. To my understanding, I should have been paid for the 2 weeks based on statutory law. Is this correct? If so, if I'm not paid out, what are my legal options? You're right. So if you give notice, generally speaking, you would have to get paid. If the company wants to be gone before, they have to pay you till the end of that notice. If you give 2 weeks notice and they want you gone today, sure, but they have to pay you for those 2 weeks. Now, that doesn't mean that you just say, hey, I'll give you 3 years notice, and if you let me go today, you have to pay me for 3 years. The employment agreement can limit that. But generally speaking, yes, if you're giving them 2 weeks notice, they absolutely will have to pay you for those 2 weeks, Breeze. So what do you do now? If your employer is not paying you, they can hear from me and they'll pay you, or you can file a claim with the Ministry of Labor and they'll get that resolved as well. But those are the options. Either have me give them a kick in the pants or have the Ministry of Labor do that. Either way, you will get paid. Yeah, very dumb for the employer to do that. Sorry about that. Hopefully you guys heard me. Not very smart for the employer to do that, Breeze. Hopefully I can help you if you want to reach me. Again, employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's continue with the questions. Khan says, what is the compensation entitlement if an employee is laid off when there is not employment agreement or any sort is in place, laid off due to the qualification issues raised from the Ministry of Education? Okay, so generally speaking, if you're asking how much you'd be owed, which you didn't give me any information about you, but I pointed you a moment ago to the severance calculator. Let me give you that information again. Go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca and click on the severance calculator. You can input there your age, the type of job that you were doing, and the length of your employment, and it's going to calculate for you what is the right amount of compensation, what is the right amount of severance that you're owed. Maybe it's 6 months, maybe it's 12 months, maybe it's something different completely. That's what it's there for you. So just go to pocketemploymentlawyer.ca, click on the severance calculator, and you can find out all the information there. Or if you want to reach me and want to have a private discussion, you can do that. Very, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. I think we should answer some more questions. Next one is from Amy. Last December, I was working a solo night shift at a retail job when I got a scam call from someone pretending to be our landlord. I followed their instructions, withdrew money from the store and some of my own money and deposited it into a Bitcoin machine. Oh my God. Not realizing it was a scam. My boss was upset but didn't fire me, and I was told not to worry about repaying it. Now that I've given my 2 weeks notice, they suddenly are demanding payment and implying I owe it. What should I do? Well, they can imply, they can demand. You don't owe it. It's something that you were doing in the course of your employment. They can't really make you pay. So there's really nothing that they can do about it. If they try to take legal action, let me know and I can help you. But no, generally speaking, if there's losses that are incurred in the course of your employment, but you're acting in good faith, you were not acting unreasonably, you weren't acting outside of the scope of your job, those things would happen and the employee can't be made to pay. It's kind of the cost of doing business. All right. So your employer really can't do anything about that. And if they try, again, you can reach me through employmentlawyer.ca. Happy to help you, but I think it's very likely if you tell your employer, sorry, I'm not going to pay that, they're not going to take legal action because they probably already got advice telling them that there's nothing they can do about it. Okay. Maybe they're just, a bit upset that you gave notice, but it doesn't change the fact that no, you don't have to, they can't force you to pay this amount. Obviously, assuming you weren't involved in the scam, etc., that there's nothing you can do. But hey, anytime someone calls you or emails you and tells you to do anything with Bitcoin, it's probably a scam. Just kind of generally speaking, that's been my experience. Unless you're talking to your boss face to face and you're discussing that with them, it's probably going to be a scam. So watch out for it. There's a lot of scammers out there that will try to take advantage of you. So don't let that happen. I think I've answered the questions that we had today. So as we wrap up this session, let me give you some contact information again. We can only get through so many things on this session, but my team and I, we're not going anywhere. We're still here to help you. Okay, if you want to connect with us at any time, it's so easy to do. As I've said, employmentlawyer.ca, the place to go there. Phone number, email addresses, everything you need. There's even a QR code on the top of the screen right there. Sorry. You can scan that and that's going to take you there as well. So please take advantage of that. We're easy to reach. I'll be back here. So will my colleagues. But the best thing is not to wait. Let us help you right away. Sometimes if you wait too long with your legal rights, you can compromise those rights. Don't let that happen to you. Guys, thank you so much for being with me today. I really enjoyed it. Really hope I've helped as many of you as possible. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. I'll talk to you all again soon. Take care of yourselves. Bye now.